afternoon. It is my great pleasure and honor to introduce someone who once upon a time was my student, then became my colleague, then became my boss, and now writes my teaching materials. No, we are so very, very honored to have Justice Elena Kagan here. I think you all know she was dean here, and also she was a Solicitor General of the United States. And I'm going to ask her some questions. I do plan to leave some time for you to ask some questions, but all of this has to happen basically in an hour and 15 minutes or something like that. So here we go. Justice Kagan, how's
It's great to see you, Dean Minow.
How's it feel to be back?
It feels great to be back. I love being here. And, I told you, this is the first time I've seen this building with everything taken down outside this building, so you can really see this building. And I think you did a great job. And congratulations, it looks splendid.
Well, it's nice of you to say, but since you designed the building, you did a great job too.
Well, it's all in the execution. So, maybe we make a great team. I design, you implement.
Here. Let me just see. We can't see the hands in the overflow rooms, but show me hands if you're a first-year student. Okay. If you're an LLM student. Okay. If you're somebody else. Thank you. Great. That gives us
What are you guys doing here?
It gives you a sense of who is here. I wanted to ask you, just as a small beginning, you have some friends in your current job who invite you to do some things that are a little unusual. I understand you've gone hunting with Justice Scalia.
That's your first question?
That's my first question. How did that come to pass, and why exactly?
Well, this is actually a pretty funny story, actually, about how it came to pass. So it started during the confirmation process. So what people don't know about the confirmation process is that in addition to the hearing itself, which, I spent 2 days sitting in front of the Senate Judiciary Committee answering the members' questions, but in addition to that, you go from office to office to office to do courtesy visits.
In the Senate.
In the Senate. And by the time I was done, I had met with 82 senators. Now, that's not the record. The record is actually held by my colleague, Justice Sotomayor, who did 91. But apparently, in that year, 9 people just said enough, right? So, but anyway, so I walk from office to office to office, and some of them last 10 minutes, some of them last an hour, but they try to engage you on matters of concern to them, but also try to do it in a way they know that you're not going to answer their questions about how you're going to decide particular cases or particular issues, but they try to get some sense of how you feel about matters of concern to them. And when you ask people about this, like, well, what do you think they asked me about most? Most people guess abortion. That's what most people, it turns out not even close. That the subject matter that I got asked about most was gun rights. Wow. And of course, people can't ask you exactly like, well, what exactly do you think of this Second Amendment issue or that Second Amendment issue? So they sort of try to feel you out a little bit. And so as a result of that, I got a lot of questions basically about whether I'd ever been hunting.
Answer was?
No. Whether I'd ever owned a gun. Answer was no. Whether I'd ever shot a gun. Answer was, again, no. I grew up in New York City, and this is not really what we did on the weekends, And so my answers on this set of subjects, which I was asked about by Republicans, which I was asked about by Democrats, which, many senators from many parts of the country were concerned about, my answers actually sounded fairly pathetic, right? Well, at a certain point in time, I was getting a little bit, actually sort of, looser and freer in the interview process. And I was talking to a senator from Idaho, and he starts, going through this litany of questions, and saying that you don't understand how important this is to my constituents because you've never really been. You've never done any of these things, and you don't know what sort of the gun culture is. And I said to him, I said, Senator, I said, if he was telling me a lot about how he hunted and where he hunted and what he hunted, and I said, Senator, if you would like to take me hunting, I'd really love to go. And this look of abject horror passes. Did this woman just invite herself hunting with me, So I stepped back a little bit, and I said, look, I didn't really mean that you have to invite me hunting, but I said, but Senator, I really appreciate and understand your concerns, and I'll tell you what, I'll make a commitment to you that if I'm lucky enough to be confirmed, I will ask Justice Scalia, whom I knew to be a great and avid hunter, I will ask Justice Scalia to take me hunting. So when I got confirmed, I went to Justice Scalia, and I told him this whole story. And he thought it was the most hilarious thing he had ever heard. And he in fact, loves introducing people to hunting because it's something that he enjoys a great deal. So we started. And so first he took me to his gun club and sort of taught me,
gun safety.
First taught me about gun safety, and then we shot clay pigeons, and so I got a sense of what I was doing out there. And then he started taking me shooting. So we went for 4 or 5 times. We went and shot birds, quail, pheasant.
What kind of gun?
A shotgun, yeah. And then at the end of my first term on the court, we had done this 3 or 4 days, 4 or 5 days, something like that. At the end of my first term, he said, Elena, it's time for us to move on to big game. So the next fall, my second year in the court, we went out to Wyoming together. We spent a week at somebody's ranch in Wyoming, and we searched high and low for antelope and deer. There was not a living thing on this ranch. I mean, it was such a bust of a hunting trip. I kept on saying to him, Nino, there's more deer in your lawn in Bethesda than, he lives in Virginia, but same thing. Anyway, we gave up on the antelope. There were no antelope to be found. We gave up on, getting a deer with the
antlers.
That you take home with you. So finally, he gave me permission to just shoot a doe so that I could say that after a week I had, and I did. So.
What gun was that?
No, so that was actually a high-powered rifle. So it's, so as much, yeah. So anyway, so we did that.
You shot Bambi.
I liked the bird shooting a lot better. I like the bird shooting, actually. It's sort of fun and challenging, and you get to see these amazing dogs work, and you're outside and you walk around a lot, and it's sort of good exercise, and it's very it's actually sort of fun. The last time somebody asked me about this was at this Ideas Festival at Aspen, and it's kind of a liberal crowd up in Aspen, Colorado, and everybody hissed. Everybody hissed when what is that about? That's terrible.
That's not good.
Yeah. So
we don't hiss at Harvard Law School.
Yeah. Terrible. So I've enjoyed my shooting with Justice Scalia, and we're going out again in a month or two. And
birds.
Yeah.
So you've started to answer a question that several people have asked me to ask you, which is, what is Justice Scalia like? How can you be friends with him?
Are you kidding? I love Justice Scalia. In fact, I like all my colleagues. But what is? I
admire him. He's a terrific man. He's a graduate of Harvard Law School.
Funny. He's totally a riot to spend time with, and I count him as a great friend. And
is he as brilliant in private as he is in public?
He's a smart guy.
Yes, he is very smart.
He is really smart, and he's really funny. You know this because there's somebody who, when you read Supreme Court argument transcripts, they actually tell you when there's laughter in the court. It's like question, da 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 da, and then there's a little bracket, and it says laughter, right? And there's somebody out there, I mean, I guess maybe there are more than one person, who literally counts every time. And there's a record that's kept of all the times that we've made people laugh.
And you notice this.
In the court. Well, I check sometimes. and Justice Scalia is so way out in front of everybody else. Justice Scalia has lapped the field 10 times. Second place is Justice Breyer. He's pretty way out in front too. And all the rest of us kind of trail behind. And I read somebody say they were looking at the standings, and they were looking particularly at my place in the standings, and I'm very securely in the middle. And I heard somebody say that they thought that I was really underperforming. So.
Well, you're doing very well so far here. Let me take you to the time before the confirmation when you were Solicitor General for the United States, and not everybody even knows what that job is. So can you explain that and explain how you organize the work there?
Well, it's an amazing job in the best lawyer's office that exists anyplace in this country, I think. It's 25 lawyers in the Justice Department. And they handle all the appellate work of the United States, of all the agencies, of all the parts of the federal government. And that means that they themselves argue all the Supreme Court cases in which the federal government plays a role. And that can either be when the United States is a party to a case, or the United States very frequently participates in Supreme Court litigation as an amicus, as a friend of the court, as somebody who's not a party to the litigation, but actually has a view about how the litigation ought to come out and has a reason to be interested in the way the litigation comes out. And the Solicitor General's office frequently participates in that kind of role. So I would say that between the two, between being a party and being an amicus, the Solicitor General's office probably participates in about 70% of what the court does, so quite a lot. And the other thing that the office does is before you get to the Supreme Court level, of course, you have another set of courts, the courts of appeals, and the Solicitor General's office, and especially the Solicitor General, has to decide which decisions to appeal to the Court of Appeals. So if the government loses in the district court, somebody has to decide whether to take that case to the Court of Appeal level, and the Solicitor General's office does that. So you decide whether to take it to a Court of Appeals level, then if you lose at the Court of Appeals, you decide whether to take it to the Supreme Court, whether to petition the Supreme Court to have the case heard. If the case is heard, you participate as a party, or if in some other case, you could participate as an amicus. So, basically, it's supervising and conducting the appellate litigation of the United States. So it's a big responsibility. It's a lot of work for only a very small set of people, and it's a great job to be in that office in general. But to be Solicitor General, it's kind of, you feel as though you're doing the best legal job in America.
Wow, you had not argued in court before that job.
You thought you'd just.
I thought I'd
point that out.
What was it like?
You were not the first person to point that out. When I went through the confirmation process, there were many people who pointed that out. In fact, before I got to the confirmation process, when the president and the president's staff asked me to do the job, the first thing I said was, you've probably come to the wrong person. There are many jobs that I think I could do in government, but this is not on the top of my list because I had never done an appellate argument before. And I think I'm a pretty good lawyer, but that's kind of a special skill, and maybe you would want to have somebody who's done it. And
pretty good lawyer when Justice Kagan was in the White House counsel's office and later deputy chief of counsel, she was described as the all-purpose brain of the White House.
Well,
pretty good lawyer.
Nice. But they said, no, we think you can do it. And so who was I to argue with them? And I did get confirmed, notwithstanding this missing element in my CV. And what was it like? The first time was a little bit terrifying, quite honestly. To be doing something at the Supreme Court level that you had never done even in a court of appeals. But I had great coaching and counseling from the other people in the Solicitor General's office. And, one thing I've learned in my life is, you're not going to know everything, and you just have to seek out the people who can teach you about things and tell you how to do the things that you haven't done before. And they were a remarkably, and are, a remarkably generous group of people, and they gave me a lot of good advice and counsel. And in general, the Solicitor General's office is very good at preparing people to argue. That even the most experienced lawyers there are people in the Solicitor General's office who have argued more than 100 Supreme Court cases, and even those people will go through multiple moot courts before they get to an argument in order to ensure that they've sort of heard every question that's going to be thrown at them, and that they've gotten people's advice about the best way to answer the most difficult questions. And so I did a bunch of moot courts, and I talked to people sort of incessantly about my first case. And you get up there, and I was very nervous, but I started talking, and then the first question was thrown at me. It was actually by Justice Scalia. It was a pretty aggressive question. And I started answering it, and I thought, well, look at this. Words are coming out of my mouth. They seem to be in sentences, You don't get a chance to talk in paragraphs at the Supreme Court, so if you can just get out a few sentences and then take the next question and do it again. And it's incredibly fun, really. It's really hard. It's really challenging, and it is hard and challenging because the court is so active these days. I mean, with almost all of us asking a lot of questions, and so the advocates have a very difficult task, but it's a ton of fun as well, and so it worked out.
And you had been, of course, a student called on in class, and you had called on people in class. So you.
Well, mostly I had called on people for a
Yes.
lot of years. Being a student was a long time ago, but it's very much like that. Is when you're sitting in a class and you're getting called on, and then you think you've answered one question okay, and the professor comes back with another and with another. I mean, that's what the experience is like, and you just have to take it in stride.
So what's it like to be on the other side asking the questions?
Well, it's a lot easier. It's a lot easier. I'm not quite sure if it's more fun because I think the challenging things are pretty fun. So the hard stuff is what's really fun. But on the other side, I mean, you're controlling it, right? When you start talking, they basically have to stop, and that makes it easier. And you've been able to prepare, and many of my questions are prepared. I mean, some of them are not. Some of them are spontaneous because of something that has been said in the court. But often I'll come in with some set of questions in my head that I think I may want to ask. So you're so much more in control than the person at the podium. And, it's a lot easier to ask the questions than to answer them, especially if you know what's coming and they don't, right? So, I try to remember what it's like to be at the podium, and I try for that. I try to treat people in the way that I would like to be treated. I'm sure sometimes I fail in that effort, but that's what I try to do. But I mean, everybody who comes to the court, I think, now knows that what they should expect is a real grilling on their case, and that we're very prepared. The court is, and the court is full of really prepared and smart people, and that means that each person is going to have the weakest parts of their case highlighted, and is not going to be allowed to just dwell on whatever the strengths of the case are, and that's what people should be prepared for.
So oral argument is, of course, just a small part of your job, but it's most visible for the public. How do you prepare for oral argument?
It is the most visible. Because it's the most visible, people think it's the most important. That's totally not the case. I mean, if you had to say which is more important, writing a great brief or delivering a great oral argument, clearly the more important is writing the great brief, because we read the briefs, and the briefs are our first entree into the case, and reading the briefs takes a while, longer than the half hour you get for oral argument, and by the time you've finished reading all the briefs, that's when you're really thinking about the case and forming a view. And that view might be tentative, and you might not think you have it all decided or thought through by the time of oral argument, but probably you've done a lot of thinking during that period. And so the best time and the best way for somebody to communicate a case is through a brief. And if the question is sort of like which is more important and which to spend more time on, the answer is spend more time on the brief. But oral argument can matter too. Some cases are really difficult, and you kind of come to a tentative judgment, but you realize it's tentative, and people can lose a case at oral argument, and people actually can win a case at oral argument. Both make people think about a case in a different way than they had coming in, or sometimes sometimes people can really come in and think of the case as on a knife's edge, and you have the ability to push people to one side or the other.
When you read the briefs in advance, what do you do with your clerks? Do they read it? Do you have a mock oral argument with them? What do you do?
Yeah, so I read the briefs. My clerks, one of my clerks reads the briefs for every case, and that clerk will write me a bench memo. And the bench memo is pretty short, and it's basically what I ask the clerk to do is to give me his or her take on just how they would come out, how they think about the case, how they would come out if they were the judge. What strikes them as as the hardest questions, what strikes them as the questions on which the case turns. And so just sort of, get a sense from them, their take on the case, if you will, including a proposed bottom line. And then they give that bench memo to me and to their co-clerks, and then all five of us will talk about the case together. And a case which I think is easy, it could be as little as half an hour, and a case that I'm struggling with, it could be as much as 2 or 3 hours. And we'll talk, and then I'll think of some questions. Maybe I'll go back and ask them to look into some things for me. But we'll talk about the strengths and weaknesses of the case and how I should come out, and we'll also talk about what questions I should ask in oral argument, and what questions would make a difference to me, or what questions might make a difference to other justices. I use oral argument for both of those purposes, both to find out things that I really want to know, and also to suggest some things to my colleagues. So we'll talk about how to approach oral argument in the course of that conversation. And then typically oral argument will happen, and then we'll typically meet again between oral argument and when the court meets in conference to vote on the cases for the first time. And I'll say to the clerks, whether I'm still thinking about it the same way, whether I need to have something else looked at, whether something's happened during oral argument to make me change my mind, or even if not change my mind, to think about the case a little bit differently. So we'll typically have another conversation, and then I go into conference.
I mean, it is a fascinating feature of the court that you don't talk to your colleagues until after oral argument.
Well, sometimes. Occasionally. I think there's actually more talking among the justices outside the conference room than people think. I think it used to happen, not at all, and people's impressions of the court are still based on that old recollection of the way things were. In fact, justices vary in how much they talk to each other, but there are some schmoozers on the court, and there are some people who walk into each other's offices and talk about, not every case, but talk about some cases. So sometimes you have a sense before oral argument about how some of your colleagues are thinking about something, and also between oral argument and conference. But it is the case that if you absolutely want to make sure that your 8 other colleagues, if you want to make sure to sort of float an idea about how to think about a case, to all of your 8 other colleagues, so that when your 8 other colleagues sit down at conference and start voting, they'll at least have heard this as a possibility. The place to do that is at oral argument. And in conference, I speak last because I'm the junior justice. So I don't have the opportunity in conference to say something before everybody else votes. And so my only place to sort of do it,
To plant an idea.
to plant an
question.
idea, is at argument.
And some people have suggested that's one reason why this bench is so hot, why there's so many questions. You're talking to each other as much as you are to the lawyers.
Yes, I mean, I think that that's not always the case. I mean, many times there really are questions that we have about the case that we want the lawyer to answer. But there's no doubt that part of what oral argument is about, it's a little bit of the justices talking to each other with some helpless person standing at the podium who you're sort of talking through. And the trick for a lawyer is, notwithstanding all these agendas of the justices, to make sure that the lawyer gets her own points across in the midst of that.
Now, a lot of the cases from the United States Supreme Court get headlines around the world. When I was in China this summer, I met with the High Judge of the People's Court there, and he asked about some of your cases, which was surprising to me. But they tend to be the high-profile cases, the same-sex marriage case, affirmative action, death penalty, abortion. What are some cases not getting that kind of attention that you wish people knew more about?
Well, what do we decide about 75 cases a year, and I suspect that the ones that land on the front pages of the newspaper are only 10, maybe, something like that. And people, I think, have an impression of the court that's based on those 10 cases, as opposed to the workload as a whole. So everybody thinks we're always divided and always divided along the same lines. And in fact, it's the case that in this past term, and similarly in other terms, half our cases are decided unanimously. And those might be cases of statutory interpretation. They might be cases of constitutional interpretation that we just all think are actually sort of easy, notwithstanding that some courts below have disagreed on them. Criminal cases, even death penalty cases, we sometimes all agree on. So there's a lot that happens at the court that where there's a lot of agreement, or where there's disagreement because it might be hard and there are good views on both sides, but not disagreement along the like everybody thinks that there are these 4 conservatives and there are these 4 liberals, and then Justice Kennedy kind of tries to make up his mind and decide the case. And
and that's not true.
It's not true of most of what we do. So I guess I wish people knew that about the court. I think that there are, every term there are some cases that I think are quite important in which big matters are being decided, and which may be actually leading to divided decisions, but they don't get as much coverage. And I wrote a couple of dissenting opinions this term on cases involving class litigation, class actions, where I think that that's true. I think that the court is doing some big things about how civil litigation is conducted in America, and things which really affect the ability of people without a lot of money to bring lawsuits to vindicate their legal rights. That are changing our litigation system in ways that I think are unfortunate and are not supported by the law that's out there. And I wish that got more attention, for example. And I think all of us could say that there are cases which are deeply meaningful and where we think the court is going in the wrong direction, but maybe don't land on the front pages of the New York Times, and that's a little bit frustrating.
The interaction between class litigation and arbitration is something you've been interested in, and so the relationship between agreements on the one hand versus laws that say individuals have rights.
Right. Well, so this is a little bit hard to explain to a
Yes.
group of people who have not had even their first law school class yet. But
Stay tuned. Yes.
Yes.
Your opinions are described as unusual in that they're readable, even by non-lawyers. And I wonder, is that your goal? And if so, why? How do you pursue it? Lincoln Kaplan wrote a piece in the New York Times in June entitled "The Talented Justice Kagan," in which he wrote, "She is a master of the topic sentence." And then he quotes you.
I do like topic sentences.
A trip
I think topic sentences
You
guide
like them?
readers. Yes.
Uh-huh.
Yeah.
Well, he quotes you. You had one, "A trip back in time begins to show why."
I'm not sure that's the greatest example, but okay.
And then also he says you're a master of the stylish dig. And his example there is wrong, wrong, and wrong again.
Well, it was responding to an argument that had 3 parts. So.
And yet he goes on, "Yet what puts her in a class by herself is her combination of down-to-earth writing and the ingredients essential to influential opinions: conceptual insight, penetrating legal analysis, and argumentative verve. Her most significant opinion this term was a dissent criticizing a court decision that kept a group of merchants from going forward with a class action
That's
against
what we were talking
American
about.
Express." That's
Yeah.
what we're talking about. He said it pretty succinctly.
Okay.
"Even though the cost of individual challenges would be greater than their potential benefit." And she wrote, quote, "To a hammer, everything looks like a nail. And to a court bent on diminishing the usefulness of Rule 23, which is the federal rule allowing class action lawsuits, everything looks like a class action ready to be dismantled." So those are pretty good. And so is this your goal, to be readable? And how do you do that?
My goal is to be very clear and to be readable and to make reading a law opinion not a labor, right? Because some legal writing can be tough to slog through, and I would like to have my opinions not tough to slog through. And I think
not just for lawyers, also non-lawyers, or
I guess I don't try to analyze it quite that specifically. What I just try to do is to write
Good
is to
writing.
write clearly and with a kind of verve. Though that's a nice word, and sometimes I succeed and sometimes I don't. But I would like people to be able to pick up a Kagan opinion and say, I know where she's going, I know why she thinks what she thinks, whether or not I agree with it. I understand the reasoning, and I actually found it not distressing to be able to get through the reasoning. I would like people to enjoy reading my opinions, and to think that they're clear, and to think that they're powerful and persuasive.
I think that you use the imperative more than anybody else. You say, consider, and then you have a hypothetical.
Well, I do sit at my computer and I write these things, and I do feel as though I'm speaking to somebody, and I want that somebody out there, whoever it is who's reading it, and it might be a lawyer doing a very specialized kind of work. I write. Believe me, I write I'm the junior justice. I write a lot of opinions in cases that are arcane and technical, where it is lawyers who are in a quite specialized field. But even they deserve to have an opinion that's enjoyable to read, and so I tried to write in a way that people can understand. I try to write in a way that people find, and not entertaining. It's not my job to entertain people, but in a way that people sort of understand the thought process and feel as though that somebody's speaking in English to them and trying to lead them through these sometimes very difficult legal concepts.
Well, you're doing that really well.
Well, thank you.
There was one that maybe was funny. So Slate noted that in your written opinion in American Trucking Association versus City of Los Angeles, Justice Elena Kagan dropped what appears to be a pretty obvious reference to an 80s pop band, Tommy
Two Tones.
So
Yeah.
you do try to make it entertaining.
Oh, every once in a while, you have to amuse yourself, you know?
You've mentioned you're a junior justice a couple of times. What are the special functions of junior justice? Are you hazed, phased? What happens here?
Well, it is an institution that runs on seniority. You know, the Chief Justice is kind of the master of everything, and then after the Chief Justice, it's how many years you've been on the court. So it goes, and this is true of the way we speak at conference. The Chief Justice will always start the discussion of the case, and he'll say, you know, the case is about X, and I think that the real question is Y, and, you know, here's what I think, and here's why I think it. And then it goes to Justice Scalia, and then it goes around the table. We all have assigned seats, and it goes around the table until it reaches me. And there's a rule that says that nobody can speak twice until everybody speaks once. This is a very good rule if you speak last, right? So that there's not a whole lot of debate before, you know, it gets to you when you have the opportunity to speak your piece. And then that can be sort of stylized, you know, as everybody goes around the table. But I think it's, you know, there are 9 of us, and we all should have an opportunity to speak our piece. And then conversation can and often does break out, and people try to forge consensus, and in cases in which consensus can be forged, or people try to debate each other and try to persuade others to their point of view. Or people try to, you know, or somebody will say, well, I don't think that answers, you know, this other question in the case, and maybe we should focus a bit on that. And so, you know, it can go back and forth afterwards, or it cannot. It can be one of those cases where we all say our piece, and either we all agree, there's nothing else to say, or we might disagree, but, you know, it's just one of those cases where it seems as though nobody's going to convince everybody else, and the only thing that further discussion is going to do is to make us all angry at each other. So why do that? And that'll be that.
You've finished your 3rd year there. Do you see some changes? Having done it now 3 times, is there a different rhythm each year?
Well, I feel changes in myself. I mean, I've obviously learned a lot, and I still have a ton to learn. Sometimes, you know, I look at my colleagues and I think, you know, they do things faster than I do, and they know more, and they've thought about questions that I haven't thought about. So I think that you know, every year is an opportunity to get a little bit more under my belt. The court does not change all that quickly. You know, the court is a pretty slow-moving institution, and I think that's probably a good thing. It's actually an institution that works very well, and that does not make changes overnight, and that there's you know, some value in that, given, you know, how well the court has served the American people for the most part over how many years.
But as you enter your 4th term, you're still junior justice, and so what does that mean? Do you have to do anything special?
Well, as I said, I go last all the time.
Right.
And, you know, sometimes people say that the junior justice gets sometimes some of the more technical, arcane cases, some of the least sexy, least glamorous cases. But in fact, the Chief Justice and the other justices who might be in opinion assigning mode, I think, are extremely fair. And
are you still running the cafeteria?
Yes. So the one thing that the junior justice does, and the Chief Justice is actually very funny when he talks about this. I've heard him say he thinks it's kind of funny. You know, somebody gets nominated and then gets confirmed to the Supreme Court, and they kind of think, well, now I'm sort of like pretty hot, right? You know, I'm sort of the best thing since sliced bread, and they're pretty impressed with themselves. And so the first thing he does is he puts them on the cafeteria committee. Where you literally sit on this committee and you think about, like, the state of the chocolate chip cookie recipe, you know? Has it changed? Is it better than last year's? Is it not as good as last year's? Then there'll be, really, people will go there. This is a committee, and people on the committee come from all different parts of the court, you know, come from the clerk's office or the police officers, and you know, somebody will say, well, there's too much salt in the soup. And then somebody else will say, no, the word I got was that there was not enough salt in the soup, you know? But we, it was.
You divide 5 to 4 on that committee?
There have been some big decisions taken on the cafeteria committee. My first year, we got a frozen yogurt machine, so I figure it was my idea. That was like the dean comes to the Supreme Court. I thought, what can I do? What would like Harvard Law School? It was like, when I became dean, I did that free coffee thing. So I did frozen yogurt at the Supreme Court, right? And just as I think I'm always known as the free coffee dean, I think I'm basically the frozen yogurt justice.
Last term, you wrote many opinions, including one addressing whether Vernon Hugh Bowman infringed Monsanto's patents when he planted soybeans that he had bought from a grain elevator. And those beans were the product of Monsanto's research. They were patented. And the company said its rights extended to the second generation of beans. And what did the court decide? And was that hard to decide?
Boy, you're bringing up some sort of technical cases for a lot of people who haven't been there. Patent law. But we decided that the farmer did infringe on Monsanto's patent. That basically the beans only replicated because of the farmer's help. The farmer's essential defense was kind of like the beans just like do their thing, and I was just kind of standing there. And we said, no, these were special genetically modified beans that Monsanto had invented.
To ward off various diseases.
At some significant cost. And we said, if you're a seed manufacturer and you put a lot of money into developing a certain kind of bean, and then everybody can go take it and just replicate them in the normal, way that people do, why would you put in all that investment? And we thought that the patent statute, in fact, did protect Monsanto in that circumstance, and that if the farmer wanted to go replicate the beans that Monsanto had invented, the farmer had to enter into a licensing agreement.
Because he had purchased beans that were meant to be consumed, either by people or by animals, but instead he planted them. You have an intriguing paragraph in the case that confines the reasoning to these facts and not to another area where there might be self-replication that could arise under a patent. And as we all know, in the digital era, there's lots of things that are patented that can involve self-replication. You say our holding today is limited. We address the situation before us rather than everyone involving a self-replicating product. We recognize such inventions are becoming ever more prevalent, complex, and diverse. In another case, the article's self-replication might occur outside the purchaser's control, or it might be necessary, but an incidental step in using the item for another purpose. What led you to write that paragraph?
Well, I think so, a little bit of humility, that we had one case before us involving one certain kind of self-replicating technology, and that there were many other cases out there involving other kinds of self-replicating technology. And that in deciding one case, we actually did not want to decide the whole world. We wanted to decide the case before us, and that there might be different arguments with respect to different technologies, and that we would be acting prematurely and unwisely if we use this case to sort of try to make law for everything and everybody we could dream of. And I think that that's, often true in law, that the court acts
case by case.
Case by case. We don't reach out, and the way the court works, which is not necessarily the way a court might say, well, there's this very hot issue out there, let's grab this issue and decide this issue. We don't do that. We decide particular parties' cases, and we are cognizant that although that case might have consequences for other cases, that law works best usually when it works, incrementally over time, case by case by case, so that you're not deciding a lot of things that you really actually don't know all that much about.
I mean, it's admirable, and yet since you do only decide 75 cases a year, and all the other courts look to you, there's a tension, right? Because you're also trying to give guidance, not just decide a case that's about the past.
Well, absolutely. I mean, you try to write your cases so that people have some sense of what the rule is that comes out of that case and how to apply the rule to other cases. But you try not to decide the universe when it's only one case before you.
Mm-hmm. I am going to, in a minute, ask you to ask some questions. This is warning. I'm not calling on you today. But if you have a question, would you come up to a microphone and stand in line? And if you get called on at that point, please introduce yourself and ask a question. I think you can tell the kinds of questions you can ask. You can ask about Justice Kagan's views on particular matters that may come before the court, or her views about really what she really thinks about me. But other than that, you can ask anything. No. So I think you understand the terms of the questions. And so think about if you have a question. And as you do, let me just ask one more, which has to do with hypotheticals and the role of hypotheticals, both in your own thinking process, in the role that you play in oral argument, in writing opinions. What is the point of a hypothetical? And how far do you go down the road of making it elaborate?
Well, these are people who are going to go into their first year of law school, many of you, and you're going to find that many of your professors start throwing hypotheticals at you. You say, well, the case should be decided this way. And the law professor will say, well, what if you change the facts so that it's a little bit more this or a little bit less that? What if you change the facts again? What if you change the facts again? When do you start saying, oh, that's different, that's different? And the reason that law professors do that is because it really makes you think about what the governing rule ought to be, about why you think what you think, about how far it extends. So just the last question you asked me, which is sort of how far do you go in any given case, hypotheticals and thinking about them, and sometimes using them when you write, can help you with that process of figuring, if this is the rule of decision for this case, well, what does it mean if the case is a little bit different, a little bit more different, a little bit more different? Where does the result start changing? Why does it start changing? And it helps really focus your thought about whether you're sure you have the right result.
Where's the line?
Where's the line?
I don't see people lining up, so please start doing that. And as you do, I have one more question that I'll ask. Your court has the custom of finishing up all of its work for the term in that year. Does this work? Does it produce a race at the end? Is there too much work, not enough work? How does that operate?
Well, it does produce an incredibly hectic spring. I mean, the way we work is we hear cases from October to April, a set of cases each month, and everything has to be decided by the end of June. So that gives us a lot of time to decide the cases from October, but not a lot of time to decide the cases from April. And typically what will happen is that the hardest cases from early in the year will be the ones that are still kind of hanging around late in the year. So you have the hardest cases from early in the year, and then you have all your March and April cases. So it makes for an incredibly packed few months at the end. But I think, we manage it pretty well. It seems as though each year I've been on the court, people have said, I don't know how we're going to get it done. And then, the virtue of deadlines is that it all does get done. And it probably gets done just as well as if you had a little bit more time because it turns out that deadlines, you all know this from like writing papers in college or something like that, deadlines focus the mind and they make you do the things that you've been putting off doing. And we manage, works.
Introduce yourself.
So thank you so much for coming today. My name is Amal Elbkar. I'm a fellow New Yorker. So I had the pleasure of actually watching a Supreme Court
And you're a first-year student.
I'm sorry?
What year are you?
Oh, 1L, so entering. I had the pleasure of watching you in your black robe in the Supreme Court. And what intrigued me the most was seeing 3 women on the Supreme Court. So how has it impacted you to have 2 other women on the Supreme Court? And how does your role as a woman on the Supreme Court sort of like affect us as women, I guess?
Yeah. So, I love my 2 women colleagues. Justice O'Connor who was the first woman Supreme Court justice, still hangs out at the building a lot, actually. She keeps an incredibly busy schedule, and she's like all over the United States and all over the world, but she comes back and still maintains offices at the Supreme Court. And I say this because Justice O'Connor has talked a good deal about how sometimes she comes in and she watches us. And she has said, from her perspective, she was the first woman, she was the only woman for many years. And from her perspective, what an amazing thing it is to watch now when there are 3 women on the court, and just by virtue of the way we sit, which is by seniority. I sit on one end of the court. My colleague, Justice Sotomayor, sits on the other end of the bench, and Justice Ginsburg sits vaguely in the middle. And so you have, 3 women from 3 women's voices coming from different parts of the bench. So a woman asks a question, and the lawyer doesn't quite exactly know where to turn, right? And just none of us are shrinking violets. We all ask, some significant number of questions. And,
all from New York.
And, all from New York. All of us have that New York accent. And sometimes I think, it's sort of a great thing. I look out in the audience. We have a lot of school kids come. It's kind of a great thing that school kids look up at us and they can see that they're women and they're doing the job, just like the men are, and that's kind of great. And certainly it was something that couldn't be said some years ago when Justice O'Connor started. Now, I say all that just to say I think it's terrific and it's meaningful in a sort of symbolic way. I actually don't think it very much, if at all, affects the way we think about cases or the way we decide cases. So I have to say that when the conference room door shuts, I just sort of haven't experienced any way in which the women have a distinctive point of view, or I just don't think it matters all that much to decision making. But I think it's a sort of powerful indicator to the legal profession and to the society at large that of the role women play in this profession. And I guess the last thing I should want to say about this is being on the court with Justice Ginsburg and with Justice O'Connor, you really get a very day-to-day sense of how much this profession has changed for women. Justice Ginsburg and Justice O'Connor, they're both about 25 years older than me and Justice Sotomayor. And in that 25 years, basically the world changed. I mean, everything changed in that 25-year period. For Justice O'Connor and for Justice Ginsburg, they get out of law school. They're absolutely star students at incredibly good law schools. They can't get a job. Nobody will hire them to clerk. Nobody wants them at their law firm. They end up constructing these careers in these remarkably inventive ways for themselves and becoming these extraordinary figures in the law. Justice Ginsburg, in fact, becomes the creator of women's rights in American constitutional law and really all the law that's helped so many, all the generations of women after them. But none of that was true for me. I mean, I got out of law school. I never experienced any of that overt discrimination that they did. And sort of what happened in that 25 years and the 2 generations of women on the court, it's just sort of there are lots of issues about women in the legal profession. I don't mean to say that there aren't, but you look at what's happened in that time span, and that's a pretty happy-making story.
No, kind of a remarkable story. So I'm a little bit older, and so when I was a law clerk at the court, there, of course, had never been a woman justice. All of the chambers had a Mr. in front of the name of the justice. And actually, the year that I was a clerk, they took the Mr. down. And that was like huge. Like you could imagine a woman being on the court. That was a big change. And then when Justice O'Connor joined, as I understand it, it's after I was there, she introduced something other than basketball for exercise. Maybe I'm wrong.
Well, I have a funny story about that. So
please.
when Justice O'Connor did get to the court, she started this exercise class. And she actually liked all the women clerks to go to her exercise class. And I was a clerk a few years after Justice O'Connor joined the court. But the court does, in fact, have a basketball court. And
The highest court in the land.
The highest court in the land. And I liked playing basketball. And I did not go to Justice O'Connor's exercise class. So one day I got injured playing basketball. I tore something in my leg, and I had to go to the hospital, and I was walking on crutches for about 4 weeks. And shortly thereafter, I'm walking down the hall and on my crutches, and Justice O'Connor is coming the other way, and she stops and she says, "What happened?" And I said, "Well, I tore whatever I tore, playing basketball." And she shakes her head very sadly, and she says, "It would not have happened in exercise class." So I've told her about the story. She claims not to remember it, but I'm sure it happened.
I'm sure it did too. I remember when you were on crutches. I'm going to call on you in a minute, but let me just say, last year on this podium, we hosted Justice O'Connor on a day devoted to work that she's inspired on civics education. And since she stepped down from the court, she's done a remarkable
Extraordinary,
job.
yeah.
Just truly, truly extraordinary. And when I told Justice Souter that she was going to come do that, he said, "I'm there." So he came too. And among other things, she learned that young people these days like games more than a lot of other ways to learn. And so she commissioned the very best people to develop a video game called iCivics that she plays. Really very, very, very remarkable.
She never rests. She's like that, what's the bunny called? The
ever ready.
Yeah,
right.
yeah.
Please.
And doing remarkably important things.
Very important. Please say who you are.
Thank you for being here today, Justice Kagan. My name is Joe Bood. I'm a transfer student starting my second year. And I'm curious about what factors go into your decision on to whether to grant cert for a petition or not, since you're faced with so many every year, and
Right.
any case could be momentous.
Right. Well, we are faced with a lot. We get about 10,000 petitions or thereabouts, and we only take about 75 of them, so that's not very good odds. But that said, it turns out that most of the 10,000 do not require a whole lot of effort to think through them. We have pretty high standards for what we take, and I think what may strike some first-year students as interesting or maybe even distressing is that we don't take cases just because we think something has happened, some error has been committed below. So being wrong is not enough to get our attention. And that means that some real injustices can occur below, and still we will not take that case. What we typically take is cases that have consequences for others than the parties in that case. So the prime example where we take a case is when a case implicates what we call a circuit split. So that means that certain courts of appeals in the country have decided to decide an issue differently from other courts of appeals in the country as to a matter of federal law, so that there should be uniformity, but there's not. It really depends on whether you live in New York or whether you live in California as to whether a conviction is valid or whether a sentence is long or short, and we view a very important part of our role as to making sure that there's uniformity across the country as to matters of federal law. Obviously as to matters of state law, states can do what they want and come out, but as to matters where there should be uniformity, we try to ensure that there is. We will always take a case where another court has struck down a statute as unconstitutional. No statute should be struck down. No federal statute should be struck down as unconstitutional, and maybe precious few state statutes without our opining on it and giving the last word. We take some cases where we just think that the case is of nationwide significance. So where a case implicates a question that's the kind of question that basically the American people do and should expect the highest court to deal with. That gives us about 75 cases a year, not all that many. Some of us think we should try to, actually a lot of us think we should maybe try to take a few more. We used to take almost twice as many as we do now. But I have to say, I sort of think that in the abstract, but I don't think we leave all that many cases on the table. I don't think that there are all that many cases that, I'm thinking, we really should have taken that. We actually do take most of the ones that I think a high court with discretionary jurisdiction ought to.
Thank you.
Who are here? Who are you?
Justice Kagan, my name is Kyle Pietari. I'm a incoming 1L. And I have a very straightforward question. What do you like to read for pleasure or to keep up with current events, or that has to do with the law?
I read all kinds of things. And I read nonfiction, I read fiction, and I actually try to do a lot of reading even during the course of the year to sort of, get myself away from law a little bit. So right now I'm reading an Ian McEwan novel, and I'm reading a book about our old boss, Thurgood Marshall, which is about this case that he litigated. Now I'm forgetting the name of the book, but this case that he litigated in the South in the late 1940s and early 1950s, the Groveland case, and it brings to mind like all the old stories that he told us about litigating in the South in the Jim Crow era, trying to eradicate Jim Crow, and also doing a lot of criminal work. And this case is about the criminal work he did. Black men who were accused of raping a white woman, who and clearly did nothing of the kind. But the justice in those days was not justice that we would recognize, and the incredible story of this case. And it's a great read.
I don't think I'm breaking any confidences if I say that Justice Kagan is an incredible reader and is always reading several books at one time, always fiction and nonfiction. I don't know how you do it. Yes, sir.
Hi, yes. My name is Derek Manners, and I'm entering first year. And I want to thank you for being with us today. My question is a hypothetical, and that is, if at some point in your hopefully long term on the Supreme Court, the more progressive wing were to gain 5 votes, would you be comfortable looking back at some of the more controversial decisions that have caused, for instance, Justice Ginsburg to say that this is one of the most activist courts in U.S. history? Would you be comfortable looking at those cases a second time, or would you want to stick mostly to cases as they come to you, year to year?
Well, the doctrine of stare decisis, which is a doctrine of precedent, is a very important part of American law and of the way the Supreme Court does its business. And it doesn't mean that one can never reverse a case that has been decided and that one thinks is wrong, but it does mean that actually you need to be able to say more than that it's wrong. That if all it takes is to reverse a case is to think it's wrong, then the doctrine of stare decisis doesn't mean anything. And there is a pretty well-developed law about what else you need to be able to say about a case to reverse it. And you don't need necessarily to say the same things about every case, but you need to show that something like that the case has proved unworkable, or that its foundations have been undermined by subsequent changes in the law or by subsequent changes in society. You need to have an account of why it's appropriate to reverse a decision that goes beyond your view that the decision was decided was incorrect the first time around. And in any circumstance, I think that's the appropriate kind of analysis to go through. And for any justice for any case that raises a question about overruling a prior precedent, there's a pretty well-developed body of precedent about when to adhere to precedent and when it's possible to depart from it.
Yes, sir.
Good afternoon, Justice Kagan. My name is Steven Salcedo. I'm a 1L from Buffalo, New York, and you've obviously had a very successful career. I'm wondering, what is the passion or the motivation that has driven you to success throughout your life?
Oh gosh, that is too hard. I'm not sure that there's been any single passion or motivation. I mean, I've tried the best I can in all the different roles that I've played and all the different jobs that I've had, to try to work as hard as I can, and to do work that I can look back on and be proud of. And that's what I'm trying to do now. But that's about as much as I can say.
Okay, thanks.
Yes.
Hi, Justice Kagan. My name is Aisha. I'm an LLM from Pakistan and New Jersey. My question has to do with what you referred to earlier. I know you said that the ideological split of the court is exaggerated, but there is some reality to the consistency in the 5-4 splits that we've seen in the more landmark decisions. So my question is, how much can a judge really disengage him or herself from their political views and opinions? How much do you read newspapers before a decision? How aware are you of the sort of current affairs that are sort of revolving around a certain issue that has come to the court? And related to that is, what has been the angriest discussion that you guys have had in the conference room? Which case has provoked the angriest discussion?
What's interesting is that we actually do not have angry discussions. I mean, and I think it's because that we're used to disagreement, and also because we're repeat players, and it doesn't really pay to get angry at people who you come back and you are going to sit on the court and have lunch with and decide cases the next day and the next day and the next day. It's not really a pleasant life to hate your colleagues. and also because I think we genuinely like each other and respect each other and view each other as acting in good faith, even though often disagreeing about certain really important matters. And I didn't mean to understate the extent to which we do sometimes disagree on important matters, matters we care about. But as I say, I don't think we get angry at each other. I think we try to persuade each other. I think we also just recognize that life is made up of different kinds of people with different points of view, and that's life. As to the first part of your question, I guess I don't think it's like politics in the ordinary sense. I think, some people say, well, they were appointed by Democrats, they were appointed by Republicans. But I just don't know of any case in which any single one of us has said, or has thought, or I would believe that people are voting, I'm voting this way because I like the president. I'm voting this way because I dislike the president. I'm voting this way because I think this is a terrific piece of legislation that I would pass. I'm voting this way because I think this is a terrible piece of legislation that I would vote no on. I mean, none of us do that. We all have a very strongly held view that we're judges and we do law, and that's something different from doing politics in the ordinary sense. Now, it is absolutely true that we have different points of view as to many matters of how to do our jobs. We might have different points of view about statutory interpretation. We might have different points of view even more about constitutional interpretation. Are we originalists, or do we adopt a different constitutional methodology? What's our understanding of the Equal Protection Clause? I mean, you could state this at higher or lower levels of generality, but there's no question that we disagree on some fundamental constitutional principles, and that results in divided judgments. But that's not to say that we're doing politics because we vote this way or we vote that way as citizens. I think we all have a very keen understanding that our role is a different one.
And as a court watcher, I would just say that every member of your court, I think remarkably, has a sense of the importance of the institution and its credibility. And that governs the work that you all do.
Yes, but I don't want to go too far on that because it's actually a difficult question, the extent to which you just call them as you see it,
Sure.
case by case by case,
Sure.
and the extent to which you think about questions of the court's credibility and legitimacy writ large. And that's a question that I think different members of the court
Different
might
views.
think differently about.
Sure.
Hello, Justice Kagan. I'm Harry Ruda. I'm a 1L from Maryland. I was wondering, of all the decisions you've written, which has been your favorite?
Gosh, what a good question. Of all the decisions I've written, which has been my favorite? Which has been your favorite?
I might know in 3 years.
It's like asking, which is your favorite child or something, Like, even if I had one, you're not supposed to say, really. Well, you stumped me. He stumped me by asking about my prime motivation in life, and you stumped me by asking. See, their questions are a lot harder than your questions.
You can think about it.
All right, I'll think about this one.
Okay.
Good afternoon, and thank you for coming today. My name is Rachel Kenningsberg, and I'm an incoming 1L. And my question is, since you've only been on the court for 3 years now, if you could go back in time and be on any court case in the Supreme Court history, is there one that you wish you could have helped decide?
She just stumped me too.
Sorry.
I'm having a hard enough time with the cases that are coming before me. I don't think I'm going to reach out for ones that I wasn't there for. There are too many cases of too much interest, of too much. I don't have the faintest idea, actually.
Okay.
Hi, Justice Kagan. My name is Bea Paterno. I'm an incoming 1L, and thank you so much for being here with us today. I think what struck me the most about what we've been talking about today is your discussion of your relationships with the other justices, and sort of collegiality, and what you said about being able to recognize when a discussion is sort of you are on two different ends and further discussion of a case would be unproductive. I'm wondering if over the past 3 years, this has obviously been a session of, at least for me, emotional ups and downs watching the court cases roll out. I'm actually a former intern in the section that once enforced the Voting Rights Act of Section 5 of the Voting Rights Act, sorry. And I'm wondering if you've, over the past 3 years, if you've seen changes in the way that each of the justices interact with each other, and if you see in the future of the court possibility to change each other's minds in a more significant way, if there's more leeway to discuss, and yeah, I guess to just sort of make each other rethink your own values and principles going into a case.
It's interesting because as I walk around and talk to people, I always find that this is the greatest point of misapprehension about the court and the justices and the way we work, is that people are somehow convinced that we should be angrier at each other than we are, and or that we and maybe it's also because maybe we have a little bit to do with this, because we'll often write pretty sharp dissents and pretty sharp rejoinders to those dissents. So sometimes you read a majority opinion, you read a dissenting opinion, and they're going after each other tooth and nail. And nobody should think, there are some cases that people feel deeply about, very strongly about, and the opinions show that. And the opinions really do go after each other. But I think we try really hard to make sure that our disagreement is put on paper. It's put there for the world to see on the cases that we feel most strongly about. People have the opportunity to understand the dissenting perspective, but you're going to disagree with each other. You're going to disagree with your classmates, and it shouldn't prevent you from being best buddies. And I think that that's like a life lesson, and it's a lesson about work relationships, and it's a lesson about friendships, and I think we do pretty well on that, and I wouldn't have it any other way. I don't want to go home angry at my colleagues. I want to go home thinking that my colleagues and I sometimes disagree, and that they're going to think I got it wrong as much as I think sometimes that they got it wrong, and that we're all going to be able to learn from each other where we can and where we can't, and where we just disagree. We learn to live with that disagreement.
You know, I promised you an hour, and we're at an hour and 15 minutes now, and so I think that's going to be it. I'm sorry, guys, but you did just say something that leads me to ask my last question, which is, you're an expert not only in the work of the Supreme Court and law and litigation, but also in this institution and legal education. And you just started to give people advice, and I wonder if you have more advice to give to people just starting out here, whether as first-year students or LLMs or transfer students or what have you. And you know, the point you just made, I guess I couldn't say better, but it doesn't mean that I'm not going to say it anyway, which is I do think that one of the critical things that we try to teach here is that you can build great personal relationships with people with whom you disagree profoundly, and you can go at it thoroughly on the intellectual front and still have good, cordial, even intimate relationships. And that's hard to do. It takes work. But boy, wouldn't the world be better if we had more people capable of doing that? So that's one thing that I guess I hope people do and work at while they're here. But do you have advice?
Yeah, well, I do think that that's really important. What other advice do I have to offer? I guess, you know, the advice that I always used to give when I was a DN was one of the great things about this law school is how much it has to offer, how there's sort of like everything under the sun. And I think that people coming in as first years, they sometimes, you know, some of you have like no clue what you want to do and want to sample everything, and that's great. To those of you who are like that, you know, I hope within at some point in the 3 years, you say, boy, this is what I really love, this is what I'm really passionate about. To the people who sort of have a sense of like, I want to do X, I hope you do some other things too, and to give yourselves really, you know, to take the opportunity to do some things you never thought you would be interested in, you never thought you would care about, because you know, it turns out that we don't know everything we don't know everything about ourselves at the age of 22 or 25 or 28 or whatever you are. And the greatness of this place is the opportunity to try new things. And I hope no matter how attached you are to some things that you care very much about, that you try some new things too.
Wonderful. You don't have a lot of time, and we are so grateful that you devoted some of your scarce time to being here and sharing your thoughts with us. You can tell this is not only a great justice, great lawyer, great human being. Thank you, Justice Kagan.
Hey, thank you. It's great to be here.